Good morning. How are you?
Doing good. We appreciate your time here. So, obviously, this is a development that not everyone was expecting. So, can you break down for me what exactly the ruling means overall?
Overall, it means that these officers, former officers, aren't facing life in prison anymore. Instead, they're facing a misdemeanor, which still is not pleasant, but that's only up to a year of prison. This ruling in this case is like a law school fact pattern. It is extremely complicated. And what happened here is the judge stepped in and said, look, the fact that these officers falsified information for a search warrant, we're not going to hold them liable for the ultimate death of Miss Taylor. And the judge is basically saying, look, there's just too many things in between A and Z that happened that could have severed the chain. And what the judge points to is the fact that Breonna Taylor's boyfriend had a weapon and shot back at police. Very controversial because this was a no-knock warrant, and the boyfriend, Kenneth Walker, had no idea who was at his door. So he had a plausible self-defense theory as well. But basically, the government was trying to say, look, we're not just going to charge these officers with the misdemeanor charge of falsifying a search warrant. That's bad enough. We're going to try to put them on the hook for the entire death. And the judge came back and essentially said, that's just too complicated.
What happens next? Is there anything else that can be done, or does it pretty much end here? Is this the end of the line, or can attorneys file something else to make this move a different direction?
The government can appeal this, and they almost certainly will. So this is going to bounce around in the courts almost for a while longer. Generally speaking, a pretrial ruling in a criminal case is subject to appeal. What ends a criminal case for good is when, under double jeopardy, when you have what we call jeopardy attaching. That's typically triggered when a jury is impaneled and sworn or a trial starts. If a case is thrown out after the jury's in the box, case is done. If it's before a jury's in the box, you can count on an opinion like this. Judge Charles Simpson issued a 33-page opinion. He showed his math in detail because he knows this is going to get slugged out in some higher courts.
I want to ask you really about the timeline here, because we know this happened back in March of 2020. We're talking more than 4 years ago. And of course, cases go through the court system. It can take years upon years. But what took so long? What took 4 years to get to this point?
You got to start at the beginning on a deal like this, right? You have a tragic incident, and that's the epicenter of all this, right? The day where this all happens. And then you have to go backwards and backwards and backwards and backwards. And to find the falsified search warrant, that takes a while to do. You're not going to find that on day one. You're probably not going to find that 6 months later. So you have to start there and then work out. So the indictments in this case came in 2022. Sometimes the court's dockets can take a while, and there's only going to be more delays in this case. So it shouldn't be that surprising. Sometimes we see justice in federal courts move rather swiftly, but sometimes it just the court we're recreating things in a courtroom, and that just sometimes takes a lot of time to do.
What sort of changes have we seen come about in Kentucky and maybe nationwide as a result of this case? We know that this was a very well-known case and still is there. So what sort of changes have happened as a result?
Beyond the social impact and beyond some of the headlines, you've got Congress considering what's called the Breonna Taylor Act, and that ends or would end functionally what you call no-knock warrants. A no-knock warrant is when a judge authorizes police to just kick in the door and to go and to deal with a situation. When police are executing a search warrant, they're going into, they don't know what they're dealing with, and they don't know what they're about to go into, depending on the type of case that they're doing. And in many instances, it has been fairly common in the past for judges to authorize police to just sort of go in there. But this is what can happen, right? When this goes haywire, it can get deadly, it can get bloody, and there are plenty of instances and plenty of cases where a homeowner is going to try to defend themselves, as they have the right to do. And so they don't know that it's the police banging down the door. I mean, imagine waking up at 2 in the morning or at 7 in the morning, which is the time when a lot of warrants are served. Imagine waking up at 7 o'clock in the morning to thunderous cracks at your door, and people just sort of storming in your house. So people are going to defend themselves in that instance. And yes, the fear of the police is that, look, if we don't do this, we're going to give the bad guys a heads up here. We're going to give them an advantage if we have to knock. They're going to start flushing evidence down the toilet. They're going to start destroying things, and they're going to go get their weapons that they didn't normally might not have at their side. So it's a very, very controversial thing. What the Breonna Taylor Act supposes is that it sort of acknowledges we can get this wrong, right? When we go into the wrong house, it's not bad, it's extra bad. And there are plenty of lawsuits and plenty of instances when they do go wrong. Statistically speaking, there's always going to be an error rate, whether you're in a hospital, whether you're in an airplane, or whether you're executing a search warrant. If you do 10,000 search warrants, you're going to get it wrong a fraction of the time. So that's sort of what that act is targeted towards. And we'll see what comes of that. But that's basically the theory.
And this is looking way, way down the line, but I want to get your legal opinion here. Do you think that this case could potentially be used as precedent for other cases, again, looking way down the line?
Certainly, because you've got here, I mean, the goal of the Justice Department was to hold these officers accountable for Miss Taylor's death. And what the government's theory is look, even falsifying a search warrant, it's criminal, but look at the potential harm that can come from it. We know search warrant executions are dangerous, and we know that it involves putting the lives of not only the law enforcement online, but the people at the residence or the place to be searched. So there's an extra responsibility that sort of goes into that. There's a concept in law that's called felony murder, which is to say that anytime you commit a felony, regardless of what that felony might be, and somebody dies as a result, you're on the hook for that death. For instance, if you're going to go rob a bank, and I don't know if you rob a lot of banks, Josh, but maybe not so much. But you go and rob a bank, right? And you go in there and look, my intent, I didn't even bring a real gun. My intent was just to go in there and to scare the clerk into giving me this. Well, we all know that if somebody who launches a plan like that or hatches a plot like that, we all know that what can happen is that somebody can get shot and killed because of a law enforcement response or a security guard response. When you do that, so the fact is you've committed a felony by robbing the bank and somebody died, therefore you're on the hook for that death. The problem with this case was that falsifying a search warrant is a misdemeanor, so you don't have that felony homicide rule. But most certainly the government was absolutely trying to send a clear message here that this type of police misconduct, we're going to punish it as severely as we can.
All right, Jeremy Rosenthal, thank you so much for joining us here to help break it down. Obviously a lot to this, so we definitely appreciate your expertise there. Anything else you want to add about this before I let you go?
We're a long way from done with this. Like I said, I mean, the public sort of focuses on the social impact of it. Obviously, this case this shooting happened in 2020, a very, very volatile time, a very volatile summer. And so that tends to be the focus of this. Legally, this is extremely complicated. Like I said, this is like a law school fact pattern, and this story is a long way from being resolved. This case is a long way from being resolved. So you will see it back in the news again. It's going to get appealed. This fact pattern is so crazy and weird, it could make its way all the way to the Supreme Court. So stay tuned.
Definitely. All right, Jeremy, we'll definitely have you back to talk more about it in the coming months, weeks, who knows? But thank you again for taking the time to be here with us today.
Thanks. Have a great day.
You too.